Zoe Smith, and I'm arguing for the spot at Google. I'm feeling confident, and I believe we're going to win because I think we have the best defense. Section 230 is in our favor, and I've done a lot of preparation for this, and I just feel pretty good.
Hi, my name is Gonzalez, and I am a amicus for Google. I think we're going to win because we have a lot of facts and I think the law on our side. I've spent a lot of time working on this, so I'm pretty excited to be able to show everyone how much work we put in.
Hi, my name is Joshua Reeves, and I'm representing Google v. Gonzalez, the Gonzalez family. I'm a defender for Gonzalez, and I'm representing the people in this case. We're feeling really good. Obviously, Gonzalez is going to win this case, and there have been a couple restless nights, but we prepared an extremely convincing legal argument, and we're obviously going to be the winners. Thanks so much.
Hey guys, I'm Kayla Walker, and I am arguing the amicus for the Gonzalez family, and we're going to win because I feel like these big tech companies and organizations have been able to promote violence and all of this stuff for way too long, and it's really time for them to be put in their place and sat down and held accountable. And everyone loves the Gonzalez family because we love them, and so there's no way that we can, because we have such a good argument, me and Josh. So yeah, people who responded better watch out.
My name is Jack Ferguson. I'm arguing for the Twitter plaintiffs against Twitter, and I'm feeling pretty good about this case. I've looked through the ins and outs. I've thought of every loophole in my argument, and as long as the justices have some common sense, I'm going to win.
Hi, I'm Jackson Baker, and I'm arguing for Twitter in the case Twitter versus Taamneh. I'm feeling pretty confident going into it. I've put in a lot of hours, a lot of work. Been working closely with Mr. McGraw and Kate Dixon, trying to hash out some of the final details of my argument. And I think I'm going to win because my argument's really strong. The Supreme Court just argued it the other day, and I think that those judges are leaning more towards my side in the actual argument, so I think I have a really good shot of winning there as well.
Welcome everyone, and thank you for attending the 15th annual session of the Cape Henry Collegiate Supreme Court. My name is Bella Genya.
I'm Marley France, and we're your hosts for today. This year's lawyers are Josh Reeves, Kayla Walker, Zoe Smith, Elena Granados, Jackson Baker, and Jack Ferguson.
And they will be arguing the cases of Gonzalez v. Google and Twitter versus Taamneh to the 9 justices today. Both cases raise the question of whether social media companies can be held liable for damage done by ISIS.
To be selected as one of our lawyers, these 6 students had to prepare and deliver a 5-minute argument for Mr. Basemeyer and Mr. McGraw on behalf of the Gonzalez family, and then prepare and deliver a 5-minute argument in favor of Google.
Since being chosen, they have gone through hours of practice in front of previous student lawyers, their peers, and practicing attorneys to prepare for tonight's argument. They committed time and effort, and they'll present the final result tonight.
Now, Taylor Urban and Monica Rudolph will give you 2 short presentations about the facts of the case and the legal arguments you will hear.
Good
afternoon, everyone. My name's Taylor, and I'm going to be debriefing you on the Gonzalez vs. Google case, which Elena, Zoe, Kayla, and Josh are going to be arguing today. Some background information. In November of 2015, Noemi Gonzalez, a 23-year-old American studying in Paris, was killed when a group of ISIS terrorists fired into a crowd of people dining in a bistro. The Gonzalez family has sued Google, owner of YouTube, for violating the Anti-Terrorism Act, JASTA, by aiding and abetting ISIS. More background information. Specifically, the Gonzalez family claims that YouTube's use of algorithms recommended ISIS videos to users and that those recommendations were critical to the growth of ISIS. Google claims that it is immune from suit because of Section 230 of the Communications Decency Act, which states, "No provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another information content provider." All parties agree that Section 230 of the Communications Decency Act means tech companies can't be sued for a decision to post or decline to post certain videos. But the question is, can they be sued for recommending a video as opposed to simply posting it? The United States District Court for the Northern District of California dismissed the case, saying that Section 230's immunity applied not only to YouTube's decisions on what to post, but also to recommendations made by YouTube's algorithms. The Gonzalez family appealed to the United States Court of Appeals for the Ninth Circuit. That court dismissed the case for the same reason. Now we're at today. The Gonzalez family appealed the case to the Supreme Court of the United States, and a decision is expected later in June. So, if the Gonzalez family wins at the Supreme Court, the case will be sent back to the District Court, and they will have a chance to prove their case to a jury. If they lose, it's over. The Gonzalez family is arguing, when recommending videos, Google is not acting as a publisher. When recommending videos, Google is not an interactive computer service, but rather a creator of content. And Google's recommendations contain information provided by Google, not information that someone else posted. Google is arguing that even when recommending videos, Google is still acting as a publisher. Even when recommending videos, Google is still an interactive computer service. And Google's recommendations include information provided by an outside source. Amicus briefs. An amicus brief is a written legal argument filed by an individual or group that is not a party to the case. So some outside groups siding with the Gonzalez family have argued that algorithms have negative effects on people and that tech companies should be held accountable for the damage that they cause. Outside groups siding with Google have argued that if tech companies become liable for algorithms, that they would have to stop using algorithms, which would be harmful to the organization of the internet. Or they would have to restrict more content, which would severely limit free speech. And that's it. Now for Monica Rudolph for Twitter versus Taamneh.
I'm going to be arguing, I'm going to be presenting Twitter v. Taamneh, the case that Jack Ferguson and Jackson Baker will be arguing tonight. Here are some of the background information or facts. January 1st, 2017, Abdulkadir Musharrafov attacked the Reyna nightclub in Istanbul, Turkey. He killed 39 people, including Naras al-Assaf. Musharrafov acted under direct instructions from ISIS. His American relatives, known as the Taamnehs, have sued Twitter under the Anti-Terrorism Act of 1990, also known as JASTA, claiming that Twitter violated JASTA by aiding and abetting the growth of ISIS. The Taamnehs do not claim that Musharrafov ever used Twitter to communicate with or learn about ISIS. They do claim that he used Twitter to grow, that Twitter knew this was happening and still allowed it to happen, and that ISIS then committed the brain attack that killed al-Assad, their relative. The question presented Is an allegation that Twitter knowingly aided and abetted the growth of ISIS legally sufficient to bring a claim under JUSTA? Or must the plaintiff show that Twitter knowingly aided and abetted ISIS in conducting the Reyna attack? The Anti-Terrorism Act, JUSTA, permits lawsuits against any person who aids and abets by knowingly providing substantial assistance or who conspires with the person who committed such an act of international terrorism. When they adopted JUSTA, Congress instructed future courts to interpret the law in a manner consistent with the previous decision of Halberstam versus Welch. In this case, the defendant's boyfriend had committed a number of burglaries and a murder. The defendant knew nothing about the crimes before they happened, but did sell the stolen property after the burglaries took place. The court found her guilty of aiding and abetting. The first court to hear this case was the United States District Court for the Northern District of California. They dismissed the lawsuit before trial because the Taamnehs could not specifically connect Twitter to the Reyna attack. The second court to hear this case was the United States Court of Appeals for the Ninth Circuit, whom overturned the district court's decision, holding that the Taamnehs' allegations that Twitter aided and abetted the growth of ISIS were sufficient to state a claim under JUSTA, even in the absence of any claim that Twitter knew about or assisted in conducting the Reyna attack. We are now at the Supreme Court. Twitter appealed this case to the Supreme Court of the United States, and a decision is expected in June. So now, if the Taamneh family wins at the Supreme Court, the case will be sent back to the district court, where they will have a chance to prove their case to a jury. And if they lose this case at the Supreme Court, then the case is over. Twitter is arguing. The Taamneh's claim fails because Twitter did not aid and abet ISIS in committing the Reyna attack. The Taamneh's claim fails because Twitter did not know about the Reyna attack before it occurred. The Taamneh's claim fails because Twitter did not provide substantial assistance to ISIS, and ruling against Twitter would have harmful consequences, especially for legitimate businesses. The Taamnehs are arguing. Their claim that Twitter knowingly aided and abetted the rise of ISIS is sufficient to state a claim under JUSTA. Twitter provided substantial assistance to ISIS, and interpreting JUSTA as Twitter suggests would render it virtually useless, as it would be almost impossible to bring a successful claim under it. And that is all. Thank you.
Now Kate Dixon is going to reveal the results of a survey that Marisol Chesla and Finley Delka gave to Cape Henry Upper School students, faculty, and staff about social media usage.
Hello, I'm Kate Dixon. Gonzalez v. Google poll data. Data collected and analyzed by Marisol Chesla and Finley and Delka. Finley and Marisol took a poll of upper school students and faculty of their use and opinions of social media. These are the results. This is the breakdown of who responded. There were 190 respondents. The most popular platform was TikTok with 30%. Second was YouTube with 22.6%, and third was Instagram with 19.5%. The most common response about how much time you spent on social media was less than 5 hours, with 27.9%. But the majority spent more than 5 hours. 7 people said they spend more than 25 hours per week. The students and faculty were asked whether they agree or disagree with this statement. I think that social media platforms should be held responsible for the real-world effects of content or propaganda spread on those platforms. A slim majority of the respondents either agreed or strongly agreed with this statement. When asked about the statement, I believe that social media platforms should exercise censorship more often in order to prevent harmful content from reaching vulnerable people. A slim majority agreed or strongly agreed. When asked about the statement, if social media platforms stopped recommending or suggesting content to me, I would not use that app as much as I do now. Almost 50% of respondents disagreed or strongly disagreed with this statement. Three trends that we found in the data, our younger students spend more time online than older classmates and faculty members. Students spend the most time on TikTok, while faculty spend the most time on Facebook. There was no relevant difference between students and faculty with respect to the 3 questions asked. Thank you.
Now it's time to get to the arguments.
The lawyers will argue their side of the case in front of 9 justices for 10 minutes each. The justices will interrupt the students with questions about the case, and the students are expected to answer on the spot within the time provided.
First, Josh Reeves, please stand, will argue on behalf of the petitioners of the Gonzalez family. Second, Kayla Walker, please stand, will argue on behalf of the Amicus Children First Association, which supports the family in this case.
Third, Zoe Smith, please stand, will argue on behalf of respondent Google.
Fourth, Elena Granados, please stand, will argue on behalf of the Amicus, the Internet Alliance, which supports Google in this case.
Fifth, Jackson Baker, please stand, will argue on behalf of petitioner Twitter.
Finally, Jack Ferguson, please stand, will argue on behalf of the respondents, the Taamneh family. After all the student lawyers have finished their arguments, the justices will then hold a short conference to vote on the cases, and then, over the course of the next few weeks, they will write an opinion announcing and explaining their decision.
During this time, the students will not know who won. They must wait until the opinion is released. The 9 justices in this case are Chief Justice Dr. Christopher Guerin, currently serves as Cape Henry's 11th head of school and president, and is a Cape Henry parent. Caroline Albert, a former member of the award-winning Columbia University mock trial team, and also holds a certificate in psychological science from the University of California, Irvine. She participated in this program as a student lawyer in 2014 and plans to attend law school next year. Lee Gregory teaches chemistry in the Cape Henry Upper School and is also an attorney specializing in patent law. Her daughter, Wesley, is a Cape Henry graduate. Manny Holiday, Esquire, practices law at Jones & Gaides in Virginia Beach and is the parent of a Cape Henry graduate. Scott Kesman practices law at Huntington Ingalls Industries and is the parent of a Cape Henry graduate. Wendy McGraw practices law at Hunton Andrews Kurth LLP and is the parent of a Cape Henry graduate. And Carson Polis is a Cape Henry senior and was voted best lawyer in last year's program. He plans to attend the Naval Academy in the fall.
Jill Walters is the upper school counselor and assistant director of student life. She is also a Cape Henry parent. Will Trager is the director of the Cape Henry Upper School and a Cape Henry parent. And now please rise as Annabelle Dewey plays the national anthem.
Good evening, everyone. Before we start with the Google case, I think it is appropriate that the court recognize Mr. Irvin, who presented earlier. Happy birthday to you. Nice of you to be here on your birthday tonight. While we go through tonight the case, I just want to let folks know one little difference is that we will allow all of the attorneys to present their statement for at least a minute or so before any of us interrupt with a question. But after that minute, then we'll definitely get to our questions with all of you. So we're going to begin with the Google case. Is the council ready?
Yes, sir.
Okay. So I know Josh Reeves is going to be arguing first with the Gonzalez family.
Justices, may it please the court, my name is Joshua Reeves, and I'm representing the petitioners, the Gonzalez family. Petitioners respectfully request this court to overturn the decision of the United States Court of Appeals for the Ninth Circuit. Your Honors, this is a case about holding an interactive web service accountable for recommending some of the most dangerous content imaginable on their site that promotes violence and terrorism to users, including children. The Gonzalez family simply wants a chance to see these social media corporations be held accountable for their reckless recommendations. For too long, have social media companies prioritized profits over the safety of their users. Google claims a parade of horribles will come for social media companies if their recommendations are not completely protected. But a parade of horribles has already come for countless families like the Gonzalez family. This case centers on the interpretation and application of Title 47 of the United States Code, Section 230C1. Section 230C1 deals with the protections given to interactive web services from legal action based on third-party content on their website. The legal question here boils down to the application of this Section 230C1 protection to Google when they personalize their recommendations. In this case, Google, through their website YouTube, recommended videos that glorified and encouraged terrorist activity to specific users, causing the growth of terrorist organizations. 1, because they do not qualify as a publisher under a proper understanding of that term. 2, because they're a provider of information themselves. And finally, 3, because they do not qualify as an interactive computer service. Google clearly should not receive these protections. The 3-part test here examines each of the 3 elements of the Section 230C1 defense. Are there any questions?
Could you elaborate on what you mean by Google is actually providing its own content?
So, in this case, Google provides their own content. Well, the Section 230C1 defense does not apply as long as the recommendation contains information provided by the respondent, and YouTube provides information in the form of phrases meant to persuade the viewer into clicking on the content. For example, phrases like suggested for you, you might like, and top picks for you. The respondent also provides information by sending notifications to their user, suggesting videos that they might find interesting. When YouTube uses language like this and suggests videos that autoplay, they're implicitly telling the user that they'll be interested in that video, which is a separate message from the video itself.
Counsel, what are you trying to hold Google liable for? The content of the ISIS videos or their recommendation?
The content is still provided by the third party, but YouTube loses this protection that they're given. They're a distributor of this content. They become a sort of co-author when they inject this information, and they're responsible for the effects, the harmful effects that this causes when viewers watch this and they commit heinous, for example, terrorist acts.
So you think that by Google recommending this video, they become a content creator of the video?
Absolutely. They become a co-author, they lose their identity as purely a publisher. If they were a publisher of this content, they would still be protected under Section 230. Secondly, with respect to determining whether Google qualifies as a publisher, Section 230C1 states that no provider of an interactive computer service may be treated as the publisher of any information provided by another content provider. Congress originally wrote this protection referring to distributor liability as opposed to publisher liability. But this distinction was abandoned by the courts soon after. It is time in this court for Section 230 to be correctly interpreted, which would result in Google being liable for their actions. That original error has led to the misunderstanding that Section 230 is an all-purpose liability shield for tech companies. As Chief Judge Katzmann pointed out in Force versus Facebook, it strains the English language to say that when recommending writings to users, a web service is acting as the publisher of information provided by another content provider.
Counsel, what is your definition of publishing that you're using?
The definition of publishing is, in this case, I would say publishing is, publishing could even include promoting, but only using a filtration device to promote, like disseminating other content. Like in the case of a Google search, Google can sort of promote the content that filters to the top. If you were to search up cat videos, Google could promote, in the case of publishing, videos that they think match your user profile best. But when Google makes these recommendations, especially on the homepage, that does not qualify as publishing under a correct interpretation of publishing in the Section 230 sense. Thirdly, with respect to whether they qualify as an interactive computer service, in this case, YouTube, as it functions right now, does not qualify as an interactive computer service because, as Section 230F2 states, an interactive computer service allows users to access online information by interacting with a computer server. For a computer to be classified as a server, it must function as a purely interactive website. When a web service goes out of its way to autoplay and recommend videos to a user in the absence of a user request, it is acting outside the definition of a server because it is not responding to a direct user request, and therefore the Section 230C1 defense would not apply.
I want to understand that. You're saying that even if there's no content, we recommend it, if they just autoplay it, you're saying they should be held liable for that as well?
I think the message, when you autoplay a video, it plays a video that they think you might like, that they're inherently sending a message to you that you might like that video by playing that video for you without a prompting from the user in any way, shape, or form. And that message, in and of itself, is sort of the information that they're providing. It takes them away from being an interactive computer server. They're no longer being interactive, and they're being proactive. They're actually pushing.
How's that any different from an editor deciding what to put in the newspaper?
An editor deciding to, well, when you decide to look at the newspaper and purchase the newspaper, it's less of an opinion article. It's more of a, when they push that on you, it's the absence of the user request where they become less interactive. In the case of a publisher in a newspaper, this isn't really talking about publishing in newspapers. It's talking about interactive web service. We come out of the publisher argument when we're talking about interactive web service in this case. The autoplay less has to do with the publisher argument and more of the interactive web service argument.
So, Counselor, even though there are ways to opt out of suggested videos, right? There are ways that you can not accept cookies and things like that, and groups like YouTube are being more sensitive to that in the face of all of this. Even though that's something that we're not forced into, your position still stands?
Absolutely. I think that just because you can opt into something, it doesn't change the meaning of the law. I think that because you can even though you can voluntarily turn off notifications and turn them on, and disable cookies, I don't think that even if you enable them, I think that it doesn't automatically make the protections or make the law invalid. It doesn't change the meaning.
So I'd be curious if you could just quickly help us to understand here. So if you didn't have the algorithm, right, they weren't being used and you weren't making these recommendations, how would this vast amount of material be organized? And so where does organization become recommendation in your opinion?
Organization becomes recommendation with as I said previously, with the injection of this information. I think that both parties do not contend that if you were to search something up on Google, search results are protected by Section 230C1. The internet simply will not be a disorganized mess, as Google claims, if Section 230 if it's correctly interpreted. Google will still be able to filter and disseminate content and organize their website in a user-friendly way without making these harmful recommendations. Even if that means that they have to police their site more avidly, it's still, I mean, that's better for the safety of...
Thank you. I see that your time is up.
Thank you so much. If I may conclude. For all these reasons, and the reasons set forth in our briefs, the decisions of the United States Circuit Courts of Appeals should be overturned. Thank you, Your Honors.
Thank you. It's a pretty bad feedback on this microphone. At this point, we'll hear from Ms. Walker, and just as a reminder to everyone, there'll be no questions to Ms. Walker.
Which microphone is it?
We could probably just turn this off. We're probably loud enough.
I think that's it.
Good evening, Justices. May it please the Court, my name is Kayla Walker, and I am representing the Children's First Association. We respectfully request that this Court overturn the ruling of the United States Court of Appeals of the Ninth Circuit on account of the social harms caused by algorithms both utilized by Google and other media platforms. Firstly, the Children's First Association would like to extend our condolences to the Gonzalez family for the loss of their daughter. Unfortunately, this is just one of the many cases that happen to involve a rise in violence due to the increasing use of media platforms. Take, for instance, 10-year-old Nyla Anderson, who was killed when she attempted to do the viral Blackout Challenge. The challenge was recommended to her by TikTok and sent directly to her For You page. This challenge encourages children to see how long they can hold their breath without, for lack of a better word, dying. However, not only has this challenge resulted in one unfortunate death, but there have been 15 deaths within the last 18 months of children younger than 12 from this challenge. This challenge is recommended to our children. Excessive use of digital platforms and social media have been shown to increase suicide-related outcomes in youth. 59% of US teens have reported being bullied on social media, and 35% of 9 to 17-year-olds report having had an online explicit encounter. Much of the damage being done to our children is a result of the algorithms that tech companies use to keep our children online. An example of this can be seen in the case of eating disorders, such as Lauren Hemmings. One of the main consequences of the use of these algorithms is obsession, and unfortunately in the case of Lauren Hemmings, that obsession with TikTok led her to developing anorexia. Before having downloaded this app, Hemmings was content with her figure, but after being continually recommended videos by both influencers who looked like her but claimed they hated their body and influencers who promoted calorie cutting and extreme dieting, she began to feel insecure about the way she looked, further increasing that eating disorder. When it comes to the intentions of these platforms, big corporations are not oblivious to what occurs on them. Former Facebook executive Frances Hauck testified before Congress that Facebook, with over 70% of the social media market, is well aware that they are increasing the risk that some children will kill themselves. On one leaked Facebook slide from 2019, Facebook admitted to, quote, making body image issues worse for 1 and 3 teen girls. Furthermore, internal Instagram research concluded that, quote, among teen users of Instagram who reported suicidal thoughts, 13% of British users and 6% of American teen users traced the desire to kill themselves back to Instagram. In fact, the significant extent of suicide and trafficking cases even led Apple in 2019 to threaten to pull Facebook and Instagram's access from the App Store. Even though they know the damage that they're doing, tech companies still hide behind Section 230 in order to avoid being held responsible. The founding purpose of the Communications Decency Act is to protect our children. Specifically, Congress ensured, quote, vigorous enforcement of federal criminal cases and punishment for trafficking in obscenity, stalking, and harassment by means of a computer. In one of the earliest cases to address Section 230, a 4-3 majority of the Florida Supreme Court held that this section provided immunity for a claim brought by a mother on the behalf of her 11-year-old son, who had been a victim of a sexual predator while using AOL. Without a care about the dramatic effects that this 11-year-old boy may have experienced, AOL felt that they fell perfectly within the definition of a publisher. As Justice Lewis stated, quote, contrary to well-established legal principles, this section has been transformed from an appropriate shield into a sword of harm and extreme danger, which places technology buzzwords and economic considerations above the safety and general welfare of our people. Lower courts have wrongly interpreted this section and have been blinded by the ever-changing appeal of technological growth. But are we really going to sacrifice the safety of our children in order to allow tech companies to make an extra dollar? Social media platforms are the only entities that can prevent and reduce the risk of injuries suffered by Noemi Gonzalez. The fact that they have this much power, yet tragic events like this still happen, leads one to wonder why platforms which are supposed to make life easier are not doing anything to stop this violence. The incomprehensible degree to which our children are suffering because big corporations and companies want to make more money is disgraceful. This court should interpret Section 230 in a way that holds tech companies accountable for the damage that they're doing. And for these reasons, the Children's First Association respectfully requests that this court overturn the ruling of the United States Court of Appeals of the Ninth Circuit. Thank you, Justices.
Thank you. We'll now hear from Ms. Smith.
Justices, may it please the court. My name is Zoe Smith, and I am representing the respondents, Google. The respondents respectfully request this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit. The court should affirm the ruling of the U.S. Court of Appeals for the following reasons. First, Section 230 of the Communications Decency Act protects interactive computer services, which Google is. Second, the Gonzalez family claims that Google went beyond the bounds of what it means to be a publisher when they recommended videos. But the job of a publisher is to organize content, which includes making relevant recommendations. Third, publishers' recommendations have created a robust, fruitful, and highly interconnected worldwide society. And fourth, if the respondents were to lose here today, utter mayhem for Google and any other social media platform would ensue at the state level. In addressing our first point, the Court of Appeals rightly ruled Google an interactive computer service, and thus protected under Section 230. Section 230 specifically defines interactive computer service to include software or enabling tools that analyze, search, subset, reorganize, or translate content, and that gives multiple people access to a computer server. And since that is the sole purpose of Google, taking in content, organizing said content, and then making it available to its 4.3 billion users, Google falls under Section 230's definition of an interactive computer service. To our second point, the Gonzalez family wrongly accused Google of not being a publisher because of the recommendation feature. But it is publishers who select speech originally produced by others and present it in an organized compilation.
Counselor, can I interrupt you for just a second?
Yes.
I was struck by Viavikas's argument regarding the TikTok recommendations for the Blackout Challenge. Is it Google's position that Section 230 protects it in those circumstances where the Blackout Challenge is being recommended to children?
So Google works a little bit differently than TikTok does. Google has a very strict policy on things they consider violent and extreme. 95% of the videos that violate this violent extremism policy are automatically removed by Google. And so when the amicus brief was being discussed, you heard no mention of Google or YouTube because that is just not how YouTube functions.
So would TikTok, under those circumstances, still get the protection of 230?
Yes, they would, because TikTok is getting these recommendations and they're recommending videos based on things like location, age, gender, etc. But again, I want to reiterate the point that this would never happen under Google because of the extreme protections they have, specifically for children. And if I may continue, the Gonzalez's wrongly accused Google of not being a publisher because of the recommendation feature. And as a publisher, Google is well within its rights to recommend relevant videos, as Congress underscored that publishing for the purposes of Section 230 includes sorting content via algorithms, and that contain tools that pick, choose, filter, and organize content. By placing pick and choose right next to each other, in this case, its plain and fundamental definition is applied, carefully choosing the things that are only wanted and needed and rejecting the others. Personalized recommendations are based on your search activity, watch activity, and other personal information willingly submitted by you, and therefore are based on things that you would be interested in.
So, counsel, can you imagine a time or a situation where a recommendation should be limited under this section?
If a recommendation is made and it is not based on anything that you willingly submitted, like your search, your age, your gender, your location, then that would be inappropriate because it's just blindly recommending content to you.
What about if it had been specifically, what if in this case, there had been a specific recommendation about the actual terrorist act?
So, I think we're getting away from the point here. The point here is whether or not recommendations are allowed. So, the specific terrorism attack, that would be covered by the Anti-Terrorism Act, and that's not exactly what we're arguing here. We're arguing whether or not recommendations are able to be made. And so, to continue, by recommending videos, Google is picking and choosing its content for users, carefully selected based on their wants and interests, as is outlined by Congress.
Counselor, when it comes to it being based on previous search activity, I know you mentioned previously that if it was not based on search activity, that should be limited, right? But where do we draw the line? If I'm watching videos about hunting and I'm interested in a particular type of weapon, but then it shows me videos about school shootings and how to carry those out, isn't it a bit of a slippery slope? Where do you believe that line should be drawn? And is it even possible to draw that line?
So it most certainly is a slippery slope, but Google is very precise with these recommendations and algorithms. They only suggest content that is specific, pertaining to what you have searched in the past. So you would not be recommended videos based on that were, school shootings just because you watch hunting videos. You would be recommended more hunting videos, but that is just out of the realm of possibility.
So how is the phrase "you might like" information provided by another information content provider? That's information provided to me by Google.
So phrases like "you might like" they are neutral. So they are not saying Google as an organization or a company might like, I know we like this content. They're saying that you might like them. They're making suggestions based on things that you have put in and matching that up directly with content created by users.
But it's Google saying that, right?
Pardon? Can you repeat that?
That's not some other content provider. That's Google telling me that, right?
Correct. And to speak on our third point, it is because of the use of recommendations that publishers can create thousands of new jobs, resources for online education, and a more unified and outspoken society. To further cite Congress's true intentions when creating Section 230, quote, "It is the policy of the United States to preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services, unfettered by federal or state regulation." Personalized recommendations are used by every big social media company: Twitter, Instagram, Etsy, and of course YouTube. These companies are successful, providers of thousands of jobs worldwide, hubs of education, communication, commerce, and free thinking. And it's not a leap of the imagination to conclude that the reason these companies are so successful, the reason they can provide so much for international society, is because they all use personalized recommendations to grow and to get people exploring new and interesting content. And that is all and more that Congress could have wanted when creating Section 230.
Counselor, pardon. I can tell you're passionate about personalized recommendations, but I'm hoping that you can help the court understand the conflict I see between the argument you're presenting and part of Google's business model. It seems to me as though, if under the theme of responsibility, that Google is quite happy to take ownership over their recommendations via paid search because it's part of their revenue stream. Google generates a great amount of profit by targeting certain people with recommendations. And so I find it hard to rectify this idea that Google is quite happy to take responsibility when it benefits Google via revenue. However, when their recommendations cause harm, they're quick to say, well, under 230, we have no responsibility for that. So help square that for the court. Why is it that you can be responsible for one set of recommendations and collect revenue, but then wash your hands of any liability when the recommendations do harm?
So I'm sensing there's this theme of big corporations against the little people, but we must understand that Google is an organization that provides jobs for thousands upon thousands of people. These are people's, sources of livelihood. So, to say that they are benefiting off of, recommending these heinous and harmful videos is just plainly untrue. And to our fourth point, we must think about the ramifications of your decision here today. If the court finds Google liable for content they recommend through their algorithms, the fate of YouTube's recommendatory algorithms would be left in the hands of the state. Each state would have wildly different opinions respecting Google's algorithms, not to mention the fact that state leadership is accustomed to change every few years. So, is Google to allow recommendations in one state and not in another? How is any single entity to keep up with multiple laws and restrictions ranging from minor differences in algorithms to literally the exact opposite? And my time is up, so may I briefly conclude?
Yes.
I want to leave you with this. Google is deeply saddened by the death of Noemi Gonzalez, and as a company, they want to be a force against terrorism, and they absolutely are. YouTube's algorithms are specifically designed to remove prohibited content. Even before Noemi Gonzalez's death in 2015, YouTube's automatic algorithms have detected approximately 95% of videos that violated their violent extremism policy. So the Gonzalez's accusation that YouTube fueled the rise of ISIS, knowingly providing substantial assistance and material support to ISIS, is a gross misjudgment. Google's algorithms, like everything, are not perfect, but they are good and they are trying their best. For the foregoing reasons, my clients respectfully request this court to affirm the decision of the U.S. Court of Appeals for the Ninth Circuit. Thank you.
Thank you. We'll now hear from Ms. Hernandez, and again, we will not have questions this period.
Justices, may it please the court. My name is Elena Granados, and I'm representing the Internet Alliance. The Alliance respectfully requests this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit. Tragic events like those at the heart of this case understandably motivate courts and others to find remedies for the victimized. And if a 25-plus-year-old statute seems to be standing in the way of that remedy, it can seem tempting to find a way around it. But it is a temptation that should be resisted. The important work Section 230 was written to do still needs to be done, and it should continue to be interpreted with the same broad protections it has always been found to have. Congress intended and correctly predicted that Section 230 would generate enormous benefits with respect to free speech, technological innovation, and the economy. Petitioners' proposal to protect removing content but not recommending it would rewrite the statute and create incentives to remove content that Congress never intended to be removed. With Section 230 in place, the internet has flourished. Companies can offer search engines, social media, customer review aggregators, crowdsourced encyclopedias, and community forums protection from being battered with lawsuits for other people's misconduct. These robust protections for interactive service providers are key to maintaining America's global competitiveness and critical to the American economy. Digital services allow millions of individuals to create small businesses, find an audience for their art, and connect with consumers eager for their services, benefiting lower-income Americans and driving America's dominance in the tech space. Liability protections and the predictability of a stable legal regime have allowed the American digital sector to flourish. Curtailing Section 230's intentionally broad protections would have catastrophic consequences for online services and the expression they enable, because Section 230 and the First Amendment work in harmony. The internet works as it does for a very good reason, and must be allowed to continue to work as intended, to make sure that those myriad of platforms and services that make the internet can still do their work supporting its operation. Reinterpreting the statute so it no longer is so broadly applicable would represent a profound policy change, with dire results to services and the expression they enable. Not only would it fail to remediate the sort of harm that occurred here, but it would invite more, affecting not just the ability to mitigate it, but to provide any benefit to anyone. If the court adopts plaintiff's interpretation of Section 230 and narrows Section 230's immunity, it will undermine the public's ability to speak, associate, and access information freely on the internet, suppress economic activity, make sexually explicit and other inappropriate content more easily accessible by minors, and place not only platforms, but also platforms' users at risk of being held liable for content created by other people. It is smaller and startup platforms especially that depend on Section 230 to foster diverse approaches to content moderation and to challenge the dominant industry leaders. Reddit's only means of removing content that violates its rules are volunteer moderators and auto-moderating tools. Etsy uses algorithms to recommend items and shops to consumers. Even Spotify uses algorithms to make custom playlists and recommend new music. Additionally, our country cannot effectively combat online threats without online platforms' participation. Limiting Section 230's immunity would discourage online platform providers from removing or downranking dangerous content. If platforms face liability for the use of algorithms to organize their content, the safe course for online platforms would be to take a hands-off approach and stop sorting and regulating content altogether. Even if petitioners' apparent and unreasonable belief that we can return to a world where algorithms do not play an important role in helping to curate online platforms were true, such a world would not be better for our national security. Given the enormous quantity of material posted online platform operators must rely in part on algorithms to identify and filter out or minimize dangerous material. George Washington University's program on extremism considers major social media companies not as auxiliary actors in online counterterrorism, but as the primary entities responsible for countering terrorist content online. Furthermore, these algorithms are just the flip side of the coin of the algorithms used to promote, suggest, or recommend good content. Maintaining Section 230 immunity will encourage operators to continue to develop sophisticated algorithms that will identify both content of interest to users and objectionable content that should be removed. Lastly, even if it is true that our society should re-examine the duties of technology companies and their users in light of the rapid evolution over the last decade of the internet, social media, and targeted recommendations, it must be Congress that decides what those changes should be and how broadly they should sweep. Judicial interpretation should not move at internet speeds. There is no telling what a sweeping order would do to the protection of Section 230 and the internet as we know it. Section 230's benefits were by design, even if Congress could not have predicted every detail or challenge of a growing internet. What Congress did know is that for the internet to grow, it had to be left alone without fear of the litigation minefield. For the foregoing reasons, the Internet Alliance respectfully requests this court to affirm the decision of the United States Court of Appeals for the Ninth Circuit.
Thank you. At this point, we are now going to switch, and we're going to hear the Twitter case. The attorney's ready. Mr. Baker then will begin.
Justices, may it please the court. My name is Jackson Baker, and I am representing the petitioners Twitter. Petitioners respectfully request this court to overturn the decision of the United States Court of Appeals for the Ninth Circuit for the following reasons. 1. The defendant did not provide substantial assistance to the specific act of international terrorism. 2. The defendant did not know about the specific act of international terrorism. And 3. Siding with the plaintiff would have terrible consequences for many legitimate businesses because they would fall subject to unjust liability. On January 1st, 2017, Abdulkadir Musharrapov, an individual affiliated with ISIS, attacked the Reyna nightclub in Istanbul, Turkey, killing 39 people. All parties agree that Musharrapov acted under direct instructions from ISIS. However, the plaintiffs have never alleged that any of the individuals who perpetrated or directed the Reyna attack ever used Twitter. In 2016, Congress amended the Anti-Terrorism Act to include the Justice Against Sponsors of Terrorism Act, or JASTA. JASTA says that liability may be asserted as to any person who aids and abets by knowingly providing substantial assistance or who conspires with the person who committed such an act of international terrorism. Congress also said that the case Halberstam v. Welch provides the proper legal framework for aiding and abetting liability. The specific text of JASTA says that substantial assistance needs to be knowingly provided by the defendant. More specifically, the final clause of the statute directs liability to the act of international terrorism. This means that in order to be held liable, the defendant would need to have knowledge of the specific act of terrorism, and the defendant would need to substantially assist that specific act. The plaintiffs have sued the defendants for aiding and abetting ISIS in committing an act of international terrorism. However, the plaintiffs have openly admitted that the defendants lacked any intent to further or aid ISIS's terrorist activities, and that the defendants rarely knew about specific terrorist accounts or posts.
Counselor, Congress has instructed us to interpret this statute as broadly as possible. Is that correct?
That's correct.
And given that direction, shouldn't we be looking more broadly at whether Twitter's activities have generally helped and supported ISIS versus whether they helped and supported a very specific act?
While Congress has said that it should be interpreted broadly, they have also said that the case Halberstam v. Welch establishes precedent for aiding and abetting liability. And under that case, there were 3 points that distilled civil aiding and abetting liability. The third point says that the defendant must knowingly and substantially assist the principal violation. In this case, the principal violation would be the attack on the Raymond nightclub. And as I mentioned previously, there is no evidence to support the fact that Twitter was ever used in any way with that specific attack. There was no mention of the attack, of that specific Reyna attack, on Twitter before the attack by any users. In fact, Twitter has actively worked to remove a lot of ISIS content from their platform. In September of 2014, they were registering 40,000 tweets per day coming directly from ISIS accounts. Today, there are less than 5,000 tweets. This proves that Twitter is not only not providing substantial assistance to ISIS, they are actively preventing the spread of ISIS by limiting the amount of content they have. It is
Counsel, do you see any difference between whether the content is on a public Twitter or is transmitted by DMs?
I do not. Well, even if the content is spread between DMs, there was no evidence. Twitter has access to this and can see this. There was no evidence to prove that the DMs were ever used to spread information about this Reyna attack. So there was no evidence to suggest that there was ever any specific knowledge on Twitter's part about this Reyna attack. So they still have immunity, even if there were no DMs by anyone, there were no public posts either. So even if that happened, it never happened. So there would be no information that Twitter could possibly have to know about that specific attack. And that's one of the main principles.
So, Counselor, so I hear that. So with Twitter, if you were going to step away from the specific attack, just to get your thoughts, do you believe that Twitter has substantially assisted ISIS in recruiting and fundraising?
I do not. As I said before, they have worked effortlessly to remove ISIS posts from their platform. This shows it's not even their responsibility to remove these posts. However, this just goes to show that Twitter has no intention of helping ISIS grow. One of the parts of Halberstam says that to determine whether a defendant has knowingly and substantially assisted the principal violation, the defendant's state of mind must be with the terrorist group. By removing this content, ISIS has proved that they are not substantially assisting ISIS because they are working actively against ISIS, proving that they are not in favor of helping ISIS.
But Counselor, in the case law that you keep referencing, if I'm not mistaken, in that case, the defendant actually had no idea that the burglaries were going to happen. So to your point about the foreknowledge before the attack, that's actually not necessary according to case law. Isn't that right?
While the defendant in Halberstam did not know about the burglaries, she still assisted in the distribution and the selling of those burgled homes. So she was still an active and willing participant of those burglaries, and by the time she was selling them, she must have had some knowledge that they had been stolen, and she still decided to help them, which proves that she still had complete knowledge of the fact that they were burgled and decided to help. That's why she was found guilty. And to that point, Twitter never knew about the Reina attack on the attack on the Reina nightclub. That's why they can't be held liable. They never knew, and they never did anything to help further the attack. They never provided ISIS with any
But did
resources.
they further the enterprise of ISIS?
Excuse me?
Did they further the enterprise known as ISIS?
They did not. As I've mentioned a couple times, they have worked effortlessly to stop ISIS from growing.
We've heard that at times 95% of the material has been removed. That's admirable. But if 5% of the material is still there, can that not substantially assist ISIS?
In this case, it doesn't matter if that 5% is generally assisting ISIS. In this case, in the context of this civil aiding and abetting liability, that 5% would need to impact and have provide significant assistance to the specific attack. And it doesn't. There's been no evidence to suggest anything about the Reina attack within Twitter, which proves that Twitter can't be held liable because they haven't provided anything to help ISIS with this attack. Going back to what Halberstam says, yes.
How should courts figure out when someone is knowingly providing assistance, and what is the line with substantial assistance? I think the problem is that we don't have a boundary line at all, and so how do we define that?
If I may, I have a hypothetical. So let's say you have a bank that is, and ISIS terrorists come in and say, we want to open a bank account. And the bank actually knows that they are terrorists and that they are going to use this money to commit this terrorist attack. And they still enable them to open a bank account and store their money, and they give them money to use for their terrorist attack. That would be an example of substantial assistance. On the other hand,
providing a platform for their communication, also providing assistance, substantial assistance?
unless they are providing a platform for communication surrounding the specific attack, which in this case would be Twitter providing substantial assistance for communication.
So with the bank, were you talking about the money had to go to that attack, or just?
Yes, the money would have to go to and be used in a specific attack that the bank was knowledgeable about. I have another example. Let's say you had a flight simulator company at the time of 9/11, and that flight simulator company trained these Al-Qaeda operatives to be able to fly planes, fully knowing that they were about to go crash into the Twin Towers. That would be another example of them substantially assisting and knowing that they would be committing a specific terrorist attack, which would be the attack on 9/11.
So what do you have to say? The JASTA Act itself states that it doesn't have to be knowingly. It can say, it can be recklessly providing material support directly or indirectly. So what I'm hearing is that recklessly and indirectly, the platform was provided. And you have the means to remove it because it's clearly ISIS is violent. And it's very reasonably foreseeable what they plan on doing.
While that might be the case, there was no substantial assistance provided. I would say that substantial assistance being provided, whether directly or indirectly, seeing that Twitter has been able to remove the vast majority, only as counsel said earlier, or as the justice said earlier.
Counsel, your time is up.
Do I have permission to wrap up quickly? Just to reiterate, Twitter cannot be held liable because they did not provide substantial assistance to the specific act of international terrorism. They did not know about the specific act of international terrorism, and siding with the plaintiff would have terrible consequences for a vast majority of of legitimate businesses. For the foregoing reasons, my client respectfully requests this court to overturn the decision of the United States Court of Appeals for the Ninth Circuit. Thank you very much.
Thank you. And finally, this evening, we'll hear from Mr. Ferguson.
This case arises from a terrorist attack on the Raina nightclub in Istanbul, Turkey, by Abdulkadir Musharrapov, an individual affiliated with and trained by ISIS. On January 1st, 2017, Musharrapov carried out a shooting massacre, firing 120 rounds into a crowd of 700 people, killing 39 and injuring 69 others. On the day of the attack, ISIS issued a statement claiming responsibility for the killings via Twitter. The Taamneh family lost their relative in the attack and has sued Twitter in response. The Ninth Circuit correctly held that anyone who aided and abetted ISIS should be liable, and the Supreme Court should uphold that decision for the following reasons. One, that Congress intended JASTA, the Justice Against Sponsors of Terrorism Act, to punish not just those who substantially assisted the commission of a terrorist act, but also those who substantially assisted a terrorist. And two, that Twitter did knowingly and substantially assist a terrorist, in this case being ISIS. The Anti-Terrorism Act was enacted in 1990 when algorithms were much weaker. In order to present liability to terrorists, it authorized American nationals injured by reason of an act or international terrorism to recover treble damages for their injuries. JASTA amended this act in 2016 to say that liability may be asserted as to any person who aids and abets by knowingly providing substantial assistance or who conspires with the person who committed such an act of international terrorism. So JASTA broadened the liability for terrorist attacks so that people could actually have the chance of recovering damages from those who committed the attacks, given that ISIS isn't going to present a lawyer to provide any form of defense or negotiation. Section 2B of JASTA states that the purpose of the act is to have the broadest possible basis. Twitter interpreted this section wrong, in that the assistance must be provided to the act, not to the person who committed it. But in reality, it's whoever aids and abets by knowingly providing substantial assistance to the person who committed such an act of international terrorism. And so,
Counsel, what's the principal violation that Twitter committed here?
Knowingly and substantially assisting a terrorist, being ISIS. The direct text...
It's not the actual terrorist attack, it's assisting ISIS. That's your argument?
Correct. That is precisely my argument.
Okay, so if I'm a journalist and I write an article, an op-ed piece that says, yeah, ISIS is bad, but hey, they brought order to this war-torn nation, and they have, garbage service, and they have banks, and they have grocery stores. Am I substantially assisting ISIS at that point? I can't express my opinion on that.
I think in that case, no. Substantial assistance is based on a series of factors from the Halberstam case, which I can go through now. So there's Section 4 of JASTA states that the law imposes civil liability on a person who conspires to commit or aid and abet by knowingly providing substantial assistance an act of international terrorism committed, planned, or authorized by a designated terrorist organization. The following three elements from the Halberstam case show that Twitter is liable for aiding and abetting an FTO, a foreign terrorist organization. The first element states that the party whom the defendant aids must perform a wrongful act that causes an injury. There is no debate that the Raina nightclub attack caused the Taamneh plaintiff's injury, being the killing of Naras Alasov. Elements 2 and 3 require the defendant to knowingly and substantially assist the principal violation.
Counselor, can I interrupt you there?
Yes.
Isn't the principal violation the specific act?
No, the principal violation is the overall assistance to the enterprise of ISIS.
So the defendant must knowingly, and the defendant here is Twitter, must knowingly and substantially assist the principal violation. So what is the principal violation that Twitter must knowingly and substantially assist?
The overall assistance to pushing ISIS's recruitment and quality and quantity of their attacks. which is their overarching goal. As for knowingly, ISIS provides these platforms to recruit individuals to join ISIS.
Counsel, I'm sorry, I want to go back to something that you had said. You had talked about points 2 and 3 of Halverson, and you then said that those say that the defendant must knowingly and substantially assist the principal violation. Is that correct?
Yes.
My understanding is that's actually point 3. And point 2 says that the defendant must be generally aware of their role as part of an overall illegal or torturous activity at the time that he provides the assistance. How are you able to prove that Twitter was aware that they were doing this?
So, ISIS depends on these platforms to recruit individuals to join ISIS, to promote its terrorist agenda, to solicit donations, to threaten and intimidate civilian populations, and to inspire violence and other terrorist activities. Twitter, like other platforms, has been aware of their assistance to ISIS for many years through media reports, statements from the government, and threatened lawsuits. The FAC suggested that Twitter is well aware of the assistance as they've refused to take aggressive steps to prevent the usage, whether it be strengthening their monetization or identifying all ISIS-affiliated accounts. On January 7th, 2016, White House officials announced that they would hold high-level discussions with Twitter to encourage them to do more to block terrorists from using their services. They stated that, and I quote, "The primary purpose is for government officials to press the biggest internet firms to take a more proactive approach to countering terrorist messages and recruitment online. That issue has long vexed U.S. counterterrorism officials as terrorist groups use Twitter to spread terrorist propaganda, cultivate followers, and steer them towards committing the violence. But the companies have resisted some requests by law enforcement leaders to take action," end quote. So, Twitter...
Counsel, let me ask you, if the same question I asked your counterpart, does it matter whether it's on public Twitter or DMs?
I would say no. I think the platforms that Twitter providing, whether that be private or public, they have control over the public and private matters, therefore they should be liable for either.
So your argument would apply equally to Verizon or T-Mobile if terrorists are sending text messages back and forth?
If the assistance is knowingly and substantial, yes.
Counselor, the concern that I'm having right now is that our court has many times viewed these social media sites as the new town square, right? We interact on social media, that's how our generation communicates. In the same way that, nefarious actors are always going to be in existence, they gather online now as opposed to in person. So where do you draw the line with this, and won't this decision necessarily impact our ability to communicate with one another in general, not just in regard to bad actors?
So, to the concern that interpreting this act to aiding and abetting the overall terrorist enterprise, the concern that this will affect internet corporations in providing any sort of assistance, I think should be dismissed on the basis that ISIS is very profound on Twitter. They're not slipping through the cracks. To give you some examples of what ISIS looks like on Twitter, in August 2014, an Australian member of ISIS tweeted a photo of his 7-year-old son holding the decapitated head of a Syrian soldier. That same month, ISIS supporters tweeted over 14...
So, Counselor, can I just... So, if we were to go along with your argument here, it seems to me that we very quickly are on a slippery slope where Twitter then becomes liable for any organization, right? Enterprise that uses it to do bad. Wouldn't they be liable? If simply by allowing a certain percentage of posts to still be on the site, if that's substantial assistance, then couldn't Twitter be found liable in, I just can't imagine, a number of possible cases. And this would be the same for other social media sites. And also, as you just suggested to one of my colleagues, T-Mobile as well. It just seems like very quickly we would be, liability for any type of crime would spread quickly.
Just to follow up on that, is there something about the recommendations that Twitter is giving that takes them outside of just allowing stuff to be posted? Is that part of your argument as well?
I don't think the matter of recommendations is relevant to the point that their platforms are being provided. And ISIS is exploiting these platforms to grow their organization. To address your question.
Argument that since they're trying to remove and are removing 95% of the ISIS posts, the very fact that those 5% remain?
So the 95% was in the case of Google. Twitter, I'm not sure what the percentage is, but it is true that they are trying to take steps to remove the ISIS-affiliated accounts. However, the Ninth Circuit stated that these steps are not aggressive enough. ISIS stated that...
Your time, Counselor.
If I may conclude the case. The Supreme Court has an important role to weigh the importance of reward versus risk in deciding this case. In siding with Twitter, you may reward the internet while maintaining a slightly higher level of freedom at the risk of allowing terrorists to continue to exploit social media platforms, which is clearly way too great of a sacrifice. All freedoms provided by the Constitution have their limits, and the freedom of speech does not go unchecked. A decision in favor of the Taamneh family will without a doubt help protect Americans in preventing the next 9/11. For the foregoing reasons, my client respectfully requests this court to uphold the decision of the U.S. Court of Appeals for the Ninth Circuit. Thank you.
If I could, I would just like to, before we go to recess, I would just like to thank all of the attorneys tonight for all of your presentations. Excellent job. Also, I think all of us would like to thank Mr. Scott McGraw, who organizes this event every year. With that, the court is now in recess.
Congratulations to all our lawyers tonight. You did an amazing job, and the justices have a tough decision ahead of them.
Thank you all for coming out tonight to support these 6 students who have dedicated a huge amount of time to this endeavor. I am sure that they all appreciate your support and your time. Bye!